When President Joe Biden came into office in January of 2020, he promised that within the first 100 days of his administration, he would send to the Senate a bill that would create a pathway to citizenship for the millions of undocumented aliens who are living in the United States today. Last week, the White House released the text of a proposed bill. In this video, I intend to go over the text of the proposed bill in order to explain to you the different categories that have been created or will be created if the bill is to become law. Now, it's important to understand a number of things about this particular bill. The bill is entitled the US Citizenship Act of 2021, and my analysis will come in just a moment. My name is William Kovatch, and I am a trained immigration lawyer. I've often been disappointed in the way immigration issues are talked about in the media, although it's not always their fault. Immigration law can be a very complex subject, touching upon constitutional issues as well as personal political points of view. My goal is to explain immigration law to you, concentrating on looking at judicial opinions and executive actions in order to explain how immigration law can have an impact on our community and on our country. I hope that you'll join me as we try to make sense of immigration law and how it may affect the average person. So last week, the White House released the text of the proposed US Citizenship Act of 2021. It's important to understand that this bill addresses more than merely a pathway to citizenship for undocumented aliens who are currently present in the United States. It addresses a number of issues in immigration law that needs urgent reform. For this video, I'm just going to concentrate on that pathway to citizenship. That pathway to citizenship is complicated enough. There are at least 4 or 5 categories of new immigrant statuses that the bill would create. It's also important to understand this is just a proposal. This is a bill. It is not a law. It is not actual legislation. It will need to be voted on by both houses in Congress. And in that regard, it's important to understand that the Democrats control the Senate right now by virtue of the fact that there's a 50-50 tie and the Vice President, Kamala Harris, is a Democrat. So Kamala Harris would cast a tie-breaking vote. But that doesn't mean that the bill is necessarily even going to come up for a vote. Because in the Senate, there is a process known as cloture. Cloture is a vote to bring a bill that is being debated to the floor for an actual vote. It's like a vote before the vote. In order to close off debate, 60 senators have to vote for cloture, which means that the Democrats will have to convince 10 Republicans to cut off debate and even allow them to vote on the bill. That virtually guarantees that the form that this bill is in now is not going to be the form that we finally end up with. In fact, it may even never get to a vote in the Senate. But even if you can get 10 Republicans to agree to allow the bill to come to a vote, you still have to deal with the fact that you need to get all 50 Democratic senators to vote for it. That's not an easy task. You see, 3 senators come from 2 states that, well, they're not known as bastion of liberalism. That's West Virginia and Arizona. Both of those states still have conservative leanings. So the 3 Democratic senators that come from those 2 states, well, they're going to have to keep in mind that they have to please their constituency. Because of that, those 3 senators are going to wield a lot of power when it comes to negotiating changes. And finally, the bill is over 300 pages long. It's 300 pages of hyper-technical legal jargon. Reporters are not necessarily going to want to read through all of it. In fact, even if they do read through all of it, if they're not trained in how to read legislation and how this legislation may interact with already passed legislation, well, they're not going to give you an accurate understanding of how the bill is supposed to work. In fact, what I've seen so far is that there are a number of reporters who are issuing analyses that are actually based on the announcement that the White House issued on President Biden's first day in office. And if you've watched any of my earlier videos, you know that those announcements, at least to me, raised a couple of questions and left some ambiguities. Well, now that I've read the text, I can address what some of those ambiguities were. Now understand, I've not written out a script for this video. I'm reading from my notes. These are notes that I took as I was reading through the legislation. So you're going to see me from time to time reading from my notes in order to get all the details correct. It's also important to understand that since we're creating 4 or 5 new categories, and I say 4 or 5 because one category addresses the dreamers, but it separates out the dreamers from people who have already received DACA. We'll get to that. But since the bill creates 4 or 5 new statuses, well, there's an area that addresses overarching requirements. So instead of repeating these requirements over and over again 4 or 5 times, the requirements get their own separate section. And that section applies to all the visas. And the most important overarching requirement has to deal with physical presence. You see, in order to qualify, an alien must have been physically present in the United States by a certain date. And that date is necessary because what you don't want to do when you have legislation like this is create a rush to the border. That is, if you pass legislation that says, hey, if you're present in the United States, you get a special immigrant status if you apply, that would create a rush of migrants trying to get across the border, sneaking across the border in order to apply. So to avoid that, the legislation creates a date that is sometime in the past that aliens had to be present by or they would not receive the status. That date happens to be January 1st, 2021. So only aliens who were present in the United States on or before January 21st, 2021 can apply. And each of the categories have a continuous presence requirement. And this means that an alien who is applying for one of these statuses, they cannot have been absent from the United States during that requirement for more than an aggregate of 180 days in a single year. So it's not like somebody wasn't able to, say, go back to their home country and then come back to the United States. It's just that if you went back to your home country and came back to the United States, you could not have been absent for more than 180 days in a single year. Another interesting thing about this act is that if it passed, it would apply to aliens who were removed during the Trump administration, or at least certain aliens who were removed during the Trump administration. So the proposal says that if an alien was removed on or after January 20th, 2017, that's the day that Donald Trump assumed office, then they can still receive this new visa or this new immigrant status despite having been deported or removed, as long as the status is being granted for humanitarian purposes. That could be, for example, for medical reasons or for family unity purposes, which means you need to come back here in order to be reunited with immediate family members. And there, if you were deported or removed after January 20th, 2017, you will need to show that you had 3 years of continuous physical presence before you were removed. Now that we've addressed the general overarching requirements, let's look at the specific new immigrant statuses that this bill would create. The first is called lawful prospective immigrant. You see, that term immigrant, it's a term of art in immigration law. It is meant to distinguish between a person who comes to the United States with the intention of living here permanently and somebody who comes to the United States only for a temporary reason, whether that's for a very specific work assignment or to come as a tourist. And somebody who comes here temporarily, they're known as non-immigrants, whereas somebody who comes here to live, they're known as immigrants. In fact, if you are applying for a non-immigrant visa, but your intention is try to stay here permanently to live, well, that can get you into a lot of trouble. That's called visa fraud, and you don't want to do that. So in order to qualify for a lawful prospective immigrant status, you need to pass background checks. It's likely an FBI background check. They'll take your fingerprints, they'll run through databases, and the whole point there is to make sure that the prospective immigrant is not a danger to public safety or the national security. There's also going to be a payment of fees. At this point, we don't know how much those fees are going to be. This new status can include children and spouses. In fact, children and spouses who qualify, they don't have to file their own petition. They can write off the main alien's petition. The status would be granted for a 6-year period, and it can be extended for another 6-year period. Now, there are restrictions with respect to somebody who's in a lawful prospective immigrant status. For example, a prospective immigrant can be eligible to receive a qualified health plan. That is, they can receive a health insurance plan through their employer or through the marketplace under the Affordable Care Act, also known as Obamacare. But a lawful prospective immigrant would be ineligible from receiving certain public benefits, such as the Premium Assistance Tax Credit. That is the subsidy that a person would receive if they were to buy their health insurance through the Obamacare marketplaces. But a lawful prospective immigrant would be able to work legally, would be able to get a Social Security number, and can travel outside the United States provided that they don't stay longer than 180 days outside of the United States in a given year. Now, a person who is a lawful prospective immigrant can apply to become a lawful permanent resident as long as they've been in lawful prospective immigrant status for at least 5 years. Now, this is important because a lawful permanent resident is an alien who is allowed to live in the United States permanently, indefinitely. That is, unless they commit a deportable act. And that means that a permanent resident doesn't have to reapply over and over again for permanent residency status. Now, let me be clear. You do need to reapply for a new green card. I think it's every 10 years, but your status doesn't expire. It's just your proof of status that you have to reapply for. And that's so they can do a background check every 10 years. At any rate, a lawful permanent resident can apply for citizenship. So in order to apply for citizenship, somebody who is an undocumented alien now would have to first apply for lawful prospective immigrant status, be in that status for 5 years, then become a permanent resident. And after becoming a permanent resident, they can apply for citizenship either 5 years afterwards or 3 years afterwards if they're married to and living with a U.S. citizen. So now let's talk about the DREAM Act. The DREAM Act applies to those aliens who were brought to the United States, say, by their parents when they were less than 18 years of age. This legislation would create a separate legal status for those young immigrants. Basically, you would have to have come here before you were 18 years of age, you would have to receive a high school diploma, and then you would have to be in school, like a college, or be in the military, or have a certain amount of earned income. A person who qualifies for this status, well, they need to register for the draft, and they can eventually become a permanent resident. Now, this bill separates out those people who are already receiving DACA, that is, Deferred Action for Childhood Arrivals. That's the program that President Obama created in 2012. In a nutshell, if you're already a DACA recipient, you're going to receive streamlined consideration for permanent residency status. We'll get to that in a bit because that streamlined consideration applies not only for DACA recipients, but also for TPS recipients. We'll get to that in just a minute, and agricultural workers. Again, we'll get to that. As I said, this is a very complicated proposal. So let's talk about those who have received TPS. TPS stands for Temporary Protected Status. Essentially what that means is you can have a country where the conditions are so dangerous that the president decides to grant temporary protected status. That means anybody who is in the United States who is from that country, they have the ability to stay in the United States instead of returning to their country, and the ability to get work authorization. Now, TPS does not lead to permanent residency, and TPS can be revoked. That was one of the problems of the Trump administration. We had a number of countries, such as El Salvador, Honduras, where TPS had been granted for over a decade. You had people who had been living here for a real long time, had created their lives here, and then, during the Trump administration, Donald Trump decided that he was not going to extend TPS status. And that left a lot of people who were in TPS, well, that left them in the lurch. They may have married a U.S. citizen, they may have had U.S. citizen children, but now they couldn't stay in the United States. They were being forced to return to their home countries and apply for a visa in a whole new process. Well, this proposed legislation says that if the country had TPS status as of January 1st, 2017 being the year Donald Trump took office, and if you were present in the United States as of January 1st, 2017, you can then qualify to become a permanent resident quicker. Similarly, agricultural workers. An agricultural worker can apply for permanent residency status if they've been performing agricultural services for 5 years before their application. And they must have had at least 2,300 hours of work or 400 work days during that period. So you may be saying, wait a minute, I thought Joe Biden was promising an 8-year path to citizenship. Where's the 8-year path to citizenship come from? Well, it's hidden. It's not readily apparent. You have to go through a lot of the act before you finally come to it. And the language, it's convoluted. You need to really understand how immigration law works in order to figure how you get the 8 years. And even then, it's only to certain categories. The Act states, any lawful permanent resident who was lawfully present in the United States and eligible for employment authorization for not less than 3 years before becoming a lawful permanent resident may be naturalized upon compliance with all other requirements of this chapter. That's a lot of legal mumbo-jumbo. What does it mean? Well, what it means is, this bill has created a new legal status, the lawful prospective immigrant status. And there are different ways to get lawful prospective immigrant status. For example, you could be in DACA and then be eligible to become a permanent resident under this proposal. Also, you could be in TPS and then become a permanent resident under this proposal. So what this means is that if you apply for permanent residency and for the 3 years beforehand you had DACA or you were in TPS, then you only have to wait 5 years to apply for citizenship. I know, convoluted. The 5 years, by the way, comes from the normal requirement of citizenship. That is, if you are a permanent resident, you have to wait 5 years before you can apply for citizenship. Although, it's 3 years if you're married to and living with a U.S. citizen spouse. So really, you could have a 6-year path to citizenship if you're married to and living with a U.S. citizen spouse. Again, it's convoluted. I'm not sure if I'm explaining this correctly because of just how complicated this is worded. But basically, you're a DACA recipient or you're on TPS. You're on DACA or TPS for 3 years, and because the bill allows you to apply for permanent residency right away, you apply for permanent residency. You get the permanent residency, you're in it for 5 years, you get your citizenship. The 3 years before permanent residency and then the 5 years in permanent residency, that's where you get your 8 years. That's why it's complicated. That's why it only applies to certain categories. So somebody who just came across the border, came here and started a business or started working, had a family here, those people are not necessarily going to qualify for the 8-year path. People in that situation, the minimum amount of time is going to be 10 years. But for people who are dreamers, people recipients of DACA or recipients of TPS, that's where you're looking at the 8-year plan. And as I expected, this bill creates separate and distinct provisions with respect to criminal convictions. Now, in an earlier video, I said there is this trend that even though the law of inadmissibility and the law of deportability addresses criminal convictions and criminal actions, that there is a trend in more recent programs to have criminal provisions that are separate and distinct from the normal criminal provisions in immigration law. This creates a very confusing circumstance, particularly DACA. If you look at DACA, you're allowed, I believe, 3 misdemeanors or 1 felony before you are now ineligible for DACA. That's different from the law of inadmissibility. You still need to be admissible. That means you still can't commit an aggravated felony. You still can't commit a drug offense. But certain crimes, take driving under the influence. Driving under the influence is not an aggravated felony, and depending, if it's not, say, a repeat offense, it's not considered a crime involving moral turpitude, so driving under the influence won't necessarily become an inadmissible or deportable offense. Now, under DACA, if you have 3 misdemeanors and one of them happens to be driving under the influence, well, yeah, and then you can lose your status. As I said, it's complicated. It's on top of the normal criminal procedures. The same is going to be true for this lawful prospective immigrant status. The lawful prospective immigrant status says if you have one felony under U.S. law, or 3 misdemeanors, you are now ineligible unless one of those misdemeanors is for possession of marijuana in a state that has legalized or decriminalized marijuana possession. So you see, again, complicated. That means if this were to pass, immigration lawyers are going to have to stay atop of all these different criminal requirements and all these different programs. Because even this, although it's similar to, say, DACA, it's somewhat different. Now, the criminal provisions, they can be waived for family unity or humanitarian purposes. This is consistent with current law in some cases. And even that waiver is really, there's a real complicated area where if you have 1 misdemeanor in the past 5 years, but your other 2 misdemeanors are in the past 10 years, well, maybe we won't let you qualify. So, not automatic. Got to know the rules, got to see how it works. And as I said, I'm not certain this is what we're going to end up with. So it's just a proposal that's out there. Now, something that did raise my eyebrow is the definition of a criminal conviction. You see, under current U.S. immigration law, criminal convictions mean any time you've been adjudicated guilty. It doesn't matter if your record's been expunged. It doesn't matter if you've been adjudicated guilty, but punishment was withheld as long as you kept your nose clean. If you were adjudicated guilty, that's it. This act would change the definition of conviction in U.S. immigration law so that if a conviction was dismissed or expunged or deferred or amended or invalidated or withheld or vacated, well, now that's no longer going to count as a conviction. What does this mean? Let me give you a concrete example. This happens in various states for minor drug convictions, for example. You may have a minor marijuana possession. You go to court, you're guilty. But what you do is instead of pleading guilty, the prosecutor may have the ability to offer something called a deferred adjudication and say, look, go through drug treatment, keep your nose clean, don't get into trouble. Come back here in a year, we'll come before the judge. If you've met all those requirements, instead of getting a guilty verdict, we're going to dismiss the charges. Well, certain circumstances, that can still qualify as a conviction. But under this new definition, it wouldn't. So that opens up a whole new area for immigration lawyers to evaluate and use for the benefit of their clients. Also, it is possible with the new definition to get a court to make a recommendation against removal. So it's not a conviction, it wouldn't be considered a conviction if in the conviction itself, in the judgment itself, you get the court to make a finding that removal is not recommended. In fact, this recommendation can come up to 180 days after the conviction. So what does this mean? Well, there's this weird problem in U.S. immigration law. U.S. immigration law and criminal law are intertwined. You can't separate them out. They affect each other. But criminal lawyers, for the most part, and state judges, they tend to have blinders on. I mean, they're aware that there are immigration issues, but they tend to not really understand them and not want to understand them. And I can tell you that from experience. I've been before Virginia lawyers with a criminal case trying to argue to a judge, hey, I would like you to understand we need to do something about this conviction because it's going to create immigration consequences. And the judge saying to me, Mr. Kovatch, I don't care. Immigration law is federal. I'm a state judge. I don't care. I'm just addressing the state criminal law issue, which technically it shouldn't. There's a Supreme Court case out there that if a conviction was a result of ineffective assistance of counsel, then the state court has the authority, indeed the duty, to go back and undo the conviction. But a lot of state court judges, they just like to ignore that and just say, nope, it's an immigration issue, blinders on, I'm not going to look at it. And, one of the problems that you have is, let's say you have a client who has a minor drug possession. Again, I keep going to that as the example because it's the easy one to explain. But if you have a client, minor drug possession problem, they go to their criminal lawyer. They ask the criminal lawyer, hey, is this going to affect my immigration status? Criminal lawyer says, nah, it's minor, it'll be no big deal. They negotiate a beautiful plea. Maybe it's a beautiful plea where they serve no jail time and they just get this minor slap on the wrist. But because it's a drug conviction, it's deportable. And because the criminal lawyer doesn't understand immigration law, they didn't understand that they've just sentenced their client to be sent back to his home country, even if that client's a permanent resident. Well, a lot of times as an immigration lawyer, I'm coming into criminal court trying to undo that, trying to fix that. That's where I get the judge telling me, Mr. Kovatch, I don't care about the immigration consequences. I'm just a state court judge, and I'm just addressing the state criminal issues, right? But at times, in certain courts, you can get a judge who's willing to say, okay, I see your point. I understand that the prior counsel didn't understand immigration law. I'm going to reopen the case, right? You could get that in some courts, not all of them. So the point of creating this 180 days after conviction to get a recommendation, that's if the alien who was convicted, maybe a permanent resident, but still an alien, they realize, because ICE came a-knocking, that by agreeing to a plea, they're still eligible to be deported. Well, they can hire a new lawyer, an immigration lawyer, who would go into state court and then ask for the state court judge to maybe amend the judgment of conviction and to include with it a recommendation against deportation or removal. And if that happens, it won't be considered a conviction under immigration law. You have to know your specific state, because some states will say, we need to have an actual procedure in state law to allow you to do this. Virginia is one. Virginia won't let you go in and just amend a criminal conviction unless there's some kind of procedure. So you would have to file a habeas corpus, and you're going to have some kind of constitutional or legal issue why you are deserving of the habeas corpus. But if you can do it, and you can do it in 180 days, you could change the conviction and get a finding that now means it's no longer going to be considered a conviction. Again, just a proposal. So we have to watch what's going to happen with this. So I've already taken up a lot of time just talking about the pathway to citizenship. As I said, this bill covers a lot more than just that. I'm not going to cover all of that right now. Instead, what I'm going to do is maybe break some of these up, address other topics as I see they're necessary, but also we need to watch how this progresses through the Senate, if it progresses through the Senate, and whether there are going to be changes. So thank you so much for watching, and as things develop, I'll come back and do some more explanations. Thank you for watching. Please remember to like and subscribe. If there are any topics you would like me to address in the future, please let me know in the comments below. Now, I don't like talking about this, but I am currently disabled because of complications following cancer surgery. If you're feeling generous, I'll have a link to my PayPal account in the description below. Thank you.